Greetings and welcome back to the Global Business Channel. Thank you for joining us today. In this video, we'll be discussing Recommendation 3 of the Financial Action Task Force's 40 recommendations concerning money laundering offenses in Part B of the FATF Recommendation Handbook. Additionally, we'll be reviewing the 7 interpretative notes accompanying Recommendation 3 found on pages 38 and 39 of the handbook. Every Saturday and Sunday, we publish videos covering topics related to offshore global business, corporate, financial, and compliance sectors. We encourage you to subscribe to the channel and give this video a thumbs up if you find these topics interesting. Without further delay, let's get started with today's video. Recommendation 3 of the Financial Action Task Force pertains to criminalization of money laundering. It suggests that countries should establish and enforce legal frameworks to define and prohibit money laundering offenses. This recommendation is grounded in international conventions such as the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, otherwise known as the Vienna Convention of 1988, and the United Nations Convention Against Transnational Organized Crime, referred to as the Palermo Convention of 2000. The essence of Recommendation 3 is to ensure that money laundering is recognized as a serious crime in national legal systems and that appropriate penalties are imposed for its commission. By criminalizing money laundering, countries are better equipped to tackle the underlying illicit activities that generate illicit proceeds such as drug trafficking, corruption, fraud, terrorism financing, and organized crime. Moreover, Recommendation 3 emphasizes the importance of applying the crime of money laundering to all serious offenses, also known as predicate offenses. This means that the scope of money laundering laws should extend beyond specific predicate crimes, for example, drug trafficking, to include a wide range of serious criminal activities. By doing so, countries can effectively disrupt the financial networks that support various forms of criminality. In practical terms, implementing Recommendation 3 involves enacting comprehensive legislation that defines money laundering offenses, establishes procedures for investigation and prosecution, and imposes appropriate sanctions on offenders. It also entails providing law enforcement agencies and judicial authorities with the necessary tools and resources to effectively combat money laundering, such as specialized training, access to financial intelligence, and international cooperation mechanisms. Overall, Recommendation 3 underscores the importance of a robust legal framework for combating money laundering, one that aligns with international standards and enables countries to take decisive action against financial crime. Compliance with this recommendation not only enhances the integrity of the financial system, but also contributes to broader efforts to combat organized crime and uphold the rule of law on a global scale. Moving on to the interpretative notes, Interpretative Note 1 states that countries should criminalize money laundering in accordance with the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances of 1988, as mentioned earlier, the Vienna Convention, and the United Nations Convention Against Transnational Organized Crime of 2000, this time the Palermo Convention. Interpretative Note 2 emphasizes that countries should apply the crime of money laundering to all serious offenses, aiming to include the broadest range of predicate offenses. Predicate offenses can be defined by referring to all offenses by setting a threshold linked to a category of serious offenses, or the applicable imprisonment penalty threshold approach by listing specific predicate offenses or by using a combination of these approaches. Interpretative Note 3 clarifies that when countries use a threshold approach, predicate offenses should at a minimum include all offenses classified as serious under their national law. Alternatively, they should encompass offenses punishable by a maximum penalty of more than 1 year's imprisonment. For countries with a minimum threshold for offenses, predicate offenses should include all offenses punishable by a minimum penalty of more than 6 months imprisonment. Interpretative Note 4 explains that regardless of the approach chosen, each country should include a variety of offenses within each designated category of offenses at a minimum. The crime of money laundering should apply to any type of property, regardless of its value, that directly or indirectly represents the proceeds of crime. Additionally, it should not be necessary to obtain a conviction for a predicate offense to prove that the property is the proceeds of crime. Interpretative Note 5 specifies that predicate offenses for money laundering should include conduct that took place in another country, provided it is an offense in that country, and would also qualify as a predicate offense if it had occurred domestically. Countries may stipulate that the sole requirement is that the conduct would have been considered a predicate offense if it had happened within their own borders. Interpretative Note 6 highlights that countries may stipulate that the offense of money laundering does not apply to individuals who committed the predicate offense if this is mandated by the fundamental principles of their domestic law. And finally, Interpretative Note 7 argues that countries should ensure the following. A. The intent and knowledge necessary to prove the offense of money laundering can be inferred from objective factual circumstances. B. Effective, proportionate, and dissuasive criminal sanctions should be imposed on individuals convicted of money laundering. C. Legal persons should be subject to criminal liability and sanctions. If this is not possible due to the fundamental principles of domestic law, civil or administrative liability and sanctions should apply. This does not preclude parallel criminal, civil, or administrative proceedings regarding legal persons in countries where multiple forms of liability are available. These measures should not affect the criminal liability of individuals. All sanctions should be effective, proportionate, and dissuasive. And finally, D, there should be appropriate ancillary offenses related to money laundering, including participation in, association with, or conspiracy to commit, attempt, aiding, and abetting, facilitating, and counseling the commission, unless prohibited by fundamental principles of domestic law. That's all for today's video on Recommendation 3 issued by the Financial Action Task Force. Thank you for staying until the end. Your support is greatly appreciated, and we hope you found the information, insights, and key points valuable. We will continue to share informative content every weekend, so be sure to return to the Global Business channel for more insightful videos on the offshore, global, and financial services sectors. Take care, stay safe, and I'll catch you in the next video. Cheerios, guys.